Okay, so you remember 3 weeks ago when Wisconsin Judge Hannah Dugan was arrested at the courthouse by FBI, ICE agents on the allegation that she obstructed an official ICE operation by concealing an undocumented immigrant that ICE agents showed up to arrest as he was appearing in her courtroom. First of all, they didn't have a proper warrant. They had an administrative warrant. They did not have an arrest warrant. An administrative warrant is basically one ICE agent signing a piece of paper saying another ICE agent can go arrest somebody. It's not an arrest warrant. Either way, she was indicted and she is moving to have those federal charges against her thrown out. So she was indicted by a grand jury, and in a grand jury proceedings are secret, but in a grand jury proceeding, the only person who presents any evidence to the grand jury is the prosecutor. Defendants are not permitted generally to be present. Their counsel is not present. Their counsel does not have an opportunity to cross-examine any witnesses who appear before that grand jury. So a prosecutor got an indictment against her, and she has moved to have those charges against her thrown out, citing the very ruling that gave President Trump a presumption of immunity against criminal prosecution for his official acts. And when she was first arrested, I was like, this is going nowhere, because judges have immunity for their official acts, and determining who is or is not present or permitted in a judge's courtroom is an official act. And that's the argument that she's making. So her legal team has filed a motion to dismiss, and within their motion, they wrote the following: the problems with this prosecution are legion, but most immediately, the government cannot prosecute Judge Dugan because she is entitled to judicial immunity for her official acts. Immunity is not a defense to the prosecution to be determined later by a jury or a court. It is an absolute bar to the prosecution at the outset. The lawyers explicitly cited the decision by the Supreme Court in Trump v. United States, which held that a president has presumption of immunity for his official acts. The attorneys focused on the Supreme Court holding that in dividing official from unofficial conduct, courts may not inquire into the president's motives. Thank John Roberts, Neil Gorsuch, Brett Kavanaugh, Alito, and Clarence Thomas for that. You can't look at the person's motives. Because Dugan's instructions within her courtroom constituted official conduct, they concluded, Judge Dugan therefore has both immunity from conviction and immunity from prosecution. She cannot even be prosecuted for anything. Even leaving this argument aside, legal experts who have studied the case believe it to be flimsy on the merits. I said that too. Wisconsin Elections Commission Chief Ann Jacobs noted in a lengthy analysis of the government's complaint that, far from obstructing the arrest of the individual in question, the jury door she ordered him to go through actually led directly into a hall full of federal agents capable of arresting him. And those agents chose not to do so until much later, when the individual in question were already on their way out of the building. So yeah, this prosecution's going absolutely nowhere, and I expect the federal judge who is hearing this motion to throw this case out and dismiss it entirely.